Good morning, good afternoon, good evening, whichever time of the day it is where you are. Thank you for joining us today. If this is your first time joining the ICCP, welcome. And if you are returning, we're glad to see you back. Right. Before I hand over to our speaker, Keith, today, I'll just go through a quick introduction of the ICCP. Let me go ahead and share my screen. Okay, so who is the ICCP and what do we do? Well, we are a professional members organization that recognizes those with the skills, qualifications, and expertise in the management of construction claims. And we have three primary objectives: to establish international professional standards, to give recognition for those who have gained the appropriate knowledge and skills in the management of claims, and to help and educate those who would like to gain that experience and knowledge. Why is there the need for the ICCP when there are so many construction organizations? Quite simply, construction claims have become a key part of the international construction industry. And our professionals come from many backgrounds, from quantity surveying, engineering, project management, and even legal. And they deserve to be recognized. But until the ICCP, there has been no institute that specifically recognizes the specialist knowledge, experience, and skills that it takes to respond to claims in the highest level of professionalism. Okay, I would like to introduce that we have 5 elected fellows in our steering committee. We also have an elected president and our executive officer, Andy Hewitt. In terms of membership, we have 3 levels of regular individual membership that each has its own criteria. We also have the special levels of student and graduate members for those who are either seeking their initial qualification or who have just recently graduated. And we also have corporate membership for companies and departments that specialize in construction claims. And in terms of member benefits, we have a members area of our website that has a collection of knowledge in the form of articles, white papers, research, etc. We have a collection of further training opportunities, not provided by us, but it's just in one place you can find the information, as well as CPD opportunities around the world. We also have a bookshop which does not sell books, but it reviews the latest industry releases. We also have a library of practical templates which help our members to save time and also ensure that their claims are completed to the highest degree of professionalism. We have regular CPD webinars such as this one. This is open to the public, but a CPD certificate is a benefit of membership. We also have the ICCP Academy, which are for members only, and those are more technical sessions. And we also offer savings on books and further training in the form of a discount from Wiley Blackwell or Rutledge, as well as our training partner claims class. We have a monthly members newsletter to keep our members in the loop about what's going on in the industry. And we have the optional benefit of the Register of Claims Practitioners, which is a popular choice with our consultant members. And we have an annual conference. Last year's conference was very popular, and based on the feedback, we have extended it to a full day this year. It is free for members, and non-members can get an extra 10 pounds off using the code webinar275, and it is currently the early bird rate of 60 pounds. So don't wait to register. You can follow the link to get the agenda and see who is speaking and the topics they'll be speaking on. Okay, and I realized that I went through that very quickly. When you registered, if you requested additional information, you will receive an email that includes this information and more. Additionally, you can visit our website, instituteccp.com, or email my colleague, Polina Ganeva at polinaganeva@instituteccp.com. And after that whirlwind introduction, I would like to hand over to our speaker today, Keith Blizzard. He has adjudicated over 400 cases over the past 25 years, so I know that I'm leaving you in very skilled hands. All right. Thank you, Keith.
Thank you very much. I'll share my screen. Well, good morning, afternoon, or evening, depending on where you are in the world. I'm Keith Blizzard. I'm a director of Blizzard's Consulting Limited. My primary profession is I'm a chartered quantity surveyor. I'm also a chartered construction manager. But more importantly for today, I'm a chartered arbitrator and a panel adjudicator. I'm also a commercial mediator, an accredited dispute board member, forensic surveyor, and visiting lecturer. What I'm going to talk about today for the next hour or so is the statutory payment regime. This is the statutory payment regime for England and Wales, Northern Ireland, and Scotland. Then I'm going to go through the JCT payment regime, and then I'm going to look at a number of payment issues, which is based upon decisions in the courts of England and Wales, and a couple including from Scotland as well. Right, the statutory payment regime comes from the legislation, which is the original Housing Grants and Construction and Regeneration Act, the HGCRA, or the Hugh Grant Act, as it was colloquially known at the time. And that was 1996. And it introduced adjudication and the payment regime for all contracts entered into on or after the 1st of May 1998. In 2009, there was the Local Democracy, Economic Development and Construction Act, which made a number of amendments to the original HGCRA, and that was operative in any contracts entered into on or after the 1st of October 2011. People get confused between the statutory payment regime and the statutory instruments, in other words, the scheme for construction contract. The actual acts, the statutory payment regime, the acts set out what every construction contract should have provisions for. If the relevant construction contract, and it's for construction works or construction operations as defined in the acts. But if a construction contract doesn't include all those requirements, then obviously there has to be default provisions. You can write them in, and you can write it into drafting contracts as long as you provide all the information which the statutes require, then that's fine. But what if they don't? Well, if they don't, they need to have default provisions. And those default provisions are provided in the Scheme for Construction Contract, England and Wales regulations. Then there was also the Scotland regulations and Northern Ireland regulations. Because of the devolution over here, the Scheme for Construction Contracts was amended, and they became the Scheme for Construction Contracts, England Wales Regulations 1998, Amendment England Regulations, because there was England, Wales, Scotland, and Northern Ireland. So the JCT payment regime simply comes from the JCT contracts, and those can be amended from time to time, provided they comply with the requirements of the statutes. Now, there's 4 important definitions set out in the statute. LDEDC changed the way the payment mechanism worked. Before we had withholding notices. The LDEDC changed that and changed the names of things. And the 4 important definitions set out in the Act were the payee. The payee is simply the person to whom the payment is due. In other words, the person to whom the payment will be made. The payer is the person from whom the payment is made, so the person who's going to write the check or do the bank transfer. And where I think a great deal of confusion has arisen is because the payment due date, it's the date provided for by the contract as the date on which the payment is due. People think, and it seems obvious into the normal use of the English language, the due date for a payment is the date it's actually going to get paid, but it's not. They came up with these weird definitions. The 4th one is the specified person is a person specified in or determined in accordance with the provisions of the contract. So, excuse me, that can be considered to be fairly unhelpful, because all it does is relates to the contract. So your contract needs to define who these people are, when the payment, who the specified person is, and when the payment due date is. Under the LDC, as we will see, the payer's obligation is to pay the notified sum, another term that was introduced. So therefore, the question is, how is the notified sum created? So how the payer pays the payee the notified sum. So how is the notified sum created? So the payer knows how much to pay, and the payee knows how much they're going to receive. Now, when considering a payment regime, it must be remembered that a payment notice is only compliant with the requirements of the Act if it states the sum the sender, the payer, considers to be or have been due of the payment due in respect of that payment. So in other words, each interim valuation, how much is actually going to be paid, that's the sum, and the basis upon which it's calculated. You can't just say, I'm going to pay you £112,118.24. To be a valid notice, you've got to say the amount that's going to be paid, whether that includes excludes VAT, and how it's calculated. So let's go on and have a look. This is the statutory payment regime. Starting from the left, you've got the due date for payment, and that's the one which the contract has to define. It could be the last Friday of the month, the 25th day of the month, whatever the first Monday of a month, or whatever. But the contract would say what the due date for payment is. That is not when you're going to get paid. That, if you look across to the far right-hand side, that is the final date for payment. So you've got the due date for payment, and under the scheme, it's 17 days. The contract can define however many days between the due date for payment and the final date for payment, which is normally, well, in the JCT contracts, it's 14 days. Quite often it's 28 days, but it can be longer as well. And certain main contractors in the past have put it up to 120 days. So that's an enormous period in time. But the statutory regime is 17 days. The contract tells you when the due date for payment is. Then within 5 days, again, I've referred to the scheme because that's the default provisions. If there's nothing in the contract about, the contract would define that number of days. But if it doesn't, then you go to the scheme, and that's 5 days. So within 5 days of the due date, the payer has to give a payment notice to the payee. Let's say it's the employer has to give a notice to the main contractor to say how much he's going to be, how much he's going intends to pay, and how that sum is calculated. Now, that then creates a notified sum. So the payer then knows the payment notice creates the notified sum, and the payee knows how much he is going to pay, how much it is going to be paid, the amount it's going to receive. Because the final date for payment is sometime hence, in other words, in this case, 17 days, if the employer or the payer wishes to pay less than the amount originally notified, it can do so, but it has to give a pay less notice. And that pay less notice simply states how much is going to be paid and the basis upon which that is calculated. Now, take a normal scenario. The employer may be making a payment, and often employers won't actually do the valuations. An independent person does, the architect or the engineer, if it's an NEC contract. Somebody will, project manager, somebody will create a valuation, a certificate. That is the payment notice. Now, let's take it simply a JCT because it's easier. If the employer wishes to deduct liquidated damages, let's say, and under the JCT contracts, liquidated damages are should be set out in the contract, but it's optional, it's discretional. It's at the discretion of the employer whether or not he wishes to deduct liquidated damages. And sometimes employers choose not to deduct liquidated damages at the time of each individual interim payment. So If the employer wishes to deduct liquidated damages, then he's going to pay less than the amount certified by the architect. The amount certified by the architect created the notified sum. If he wishes to pay less simply by the deduction of liquidated damages, then the payer or the employer has to issue a pay less notice, showing that the way it's been calculated, the sum that's going to be paid, and the way it's been calculated is simply the architect's certificate, but you still have to have the full build-up of the architect's certificate, and then you just take on the deduction of liquidated damages. Now, it may be during the interim period between the payment notice and when the pay less notice can be given, then the pay less notice may include things like if the architect's decided that the materials on site, the windows were delivered, but they're wrong. He included the delivery of the windows in its interim valuation, in its interim certificate, but that's no longer valid. So, in fact, the employer can then say, I'm not paying for those windows because they're found to be defective or they're not the correct windows, and therefore the calculation of the notified sum is changed because that amount is not included. It's not omitted, it's not included, because with the valuations now, you start from zero, whether you're issuing a payment notice or a pay less notice, you start from zero and build up. So if you're going to include, let's say, materials on site and £40,000 for the windows, and those windows are found to be incorrect, when you create your pay less notice, all that happens is you calculate the total value again, but you simply don't include the 40,000. You don't start with the gross value as set out in the payment certificate and then say, I'm not paying for this, and this, because that's the old withholding regime. That's not the correct way to do it. Now then, the contract will define how much time before the final date for payment that any pay less notice has to be issued. Again, I've used the scheme, and the scheme says it's no later than 7 days before the final date for payment. So in fact, if you go from the left, the due date for payment plus 5 days, you get the payment notice, but the final date for payment, you come back from that date by the number of days. And that's when a pay less notice has to be given. So you need to have in the contract the due date and how to calculate the final date for payment. And if you don't, then it defaults to the scheme, which would be 17 days. So basically, following this and the scheme, what you've got is you've got the due date for payment, 5 days, maximum 5 days later, the architect issues a certificate. There's 17 days since the due date, so there's only 12 days left if it's done on day 5, 12 days left before the final date for payment. So in fact, a pay less notice has to be given no later than 7 days before that final date for payment. So of those 12 days, bring back 7, and he's only got 5 days in the middle. So the distance between the payment notice and the pay less notice is actually only 5 days if you're using the scheme and the final date for payment is 17 days after the due date. I hope that's all easy and clear. Now then, what happens if for some reason the architect or the employer, the payer, doesn't issue the payment notice? No notified sum is created. So without some other provisions, the contractor would never get paid. So what the Act says is, if within the period, the 5 days, or whatever the period is in the contract, a payment notice is not given, no notified sum is created. So in fact, the payee, the recipient, the contractor can send a payment notice back the other way to the employer and say, you were supposed to have issued your payment notice yesterday, you didn't, here's our application for payment. And that then creates the notified sum. Now, the problem with that is, what if the contractor doesn't notice on day 5 that the payment notice hasn't been given? Well, what the Act says is that any time after the 5 days is up, the contractor can send its application for payment. But if it doesn't do it straight away, obviously the final date for payment may not be met, because what you've got is that the default notice goes across the timeline from left to right. And you may be in the position whereby the contractor doesn't realise until day 18 after the due date for payment, or even, let's say, the end of the month, 28 days after the due date, he hasn't had an application. So no notified sum has been created. So the payer doesn't have to make any payment to him. In that case, then the contractor can send a default notice back saying, this is the amount I value the works and this is what I want paying. But obviously that's off the end of the right hand side of the diagram. So what the Act says is that the default notice extends the final date for payment. So what happens is the number of days between the payment notice and the date when the default notice is given, however many days that is, whether it's 1, 2, 3, 20, that extends the final date for payment by the same amount. So a day, 2 days, 20 days, however many days after the payment notice should have been given, that the default notice was given. And because you calculate the final date for sending a pay less notice back from the final date for payment, obviously that moves out as well. So if you've got, let's take this diagram, say it's a day between the payment notice and the default notice being sent, then the final date for payment moves across to the right by 1 day. But the pay less notice has to be given no later than 7 days before the actual final date for payment, which is moved out 1 day to the right. Again, I hope that's clear. But again, the pay less notice has to give the same information as before. Now then, the Act also did think about this when they were drafting the Act. They did think about this and thought, well, hang on, that can be a bit unfair, really, because it's putting the onus on the contractor to make an application. So what they included in the Act was an additional provision that provided the contract between the parties allows for the contractor to make an application for payment before the due date, then if he makes that application, it doesn't create a notified sum. It's just their application for a payment. Go past the due date, get to the payment notice date, 5 days later in this case. If no certificate is issued or no payment notice is issued by the payer, then the contractor, the payee, doesn't have to issue a default notice. And as soon as the payment notice is not given on the final date for payment, the contractor's application then stands as a default notice. But what they also said was if the contract provides, and it has to be in the contract, the statute simply says your contract, if it provides this. So it's not a part of the statutory regime that you can make an application. A contractor can make an application before the due date, and that would then automatically become the default. If the payment notice is not given, it automatically becomes the notified sum. So if the contract provides that you can make the contractor can make an application before the due date, he makes an application before the due date, no payment notice is given, the contractor is not then allowed to make, if he's made an application before the due date, he's not allowed to make another application as a default notice. In other words, the contractor can't sit there and say, well, I've made an application for £20,000, an interim payment of £20,000. He hasn't issued a payment notice, so they've obviously messed this up. So I'll send them a default notice for 200,000 or some other sum. So it's simply now about the creation of the notified sum, which the obligation of the payer is to pay on the final date for payment. Again, I hope that is all perfectly clear. I know I'm going through this at a fair old speed. So what's the JCT payment mechanism? Well, under the JCT, you've still got the due date for payment because that's what the law, the statute says you have to. Then you've got the interim certificate, which happens to be 5 days after the due date. The contractor can put an interim payment notice in if the architect doesn't issue a certificate, and the final date for payment is 14 days under the JCT rather than the 17 under the scheme, and the pay less notice is no later than 5 days before the final date for payment rather than the 7 which is in the scheme. Again, under the JCTs, the contractor is, a lot of the JCTs, it can be deleted from the contract, but if it's left in the contract, then the JCT allows the contractor to make an application for interim payment before the due date, in which case, if the architect doesn't issue an interim certificate, that then creates the notified sum automatically, and the contractor, it effectively becomes the contractor's interim payment notice, but immediately upon the architect not issuing a certificate. Now, I've seen contracts amended. It tends to be 5 days or thereabout between the due date and the interim certificate, but it can be longer. The final date for a pay less notice before the final date for payment, I've seen that reduced to 24 hours, 1 day. It's often reduced to 2 or 3 days, but it counts as that period can be shortened. So the pay less notice, the payer has got up until the day before, or say 2 days before, or 3 days before, whatever, before they have to give a final the date for a pay less notice. So those are the two payment regimes, and I've tried to explain as well how the contracts can be amended and things that I've seen. So what I'm going to do now is to run through a number of cases, which there are over 400 reported cases on adjudication. I'm not doing 400, I'm doing a few, and I've pulled out things which are relevant to claims practitioners, because it's information you need to know whether you're going to make a claim and to run an adjudication, whether your client has the capability, the opportunity to run a claim. In ISG, and these go back to 2014, ISG and CVIC, the lack of a pay less notice meant the employer had agreed the value of the works the contractor claimed in an interim certificate. So the contractor had claimed it, made an application for a payment, and what the court decided, or the judging it's the court decided what the lack of a payment notice meant the employer had agreed the value of the work, which that's where we were. We're not there now, but that's where we were. But this particular case was important because it established that the concept that each payment cycle, each interim payment notice was to be considered separately, and there could only be one adjudication per payment cycle. Now, when the LDEDC came in, because of this, the wording and the payment regime which I've described, what if you were late? You issued an interim certificate, but not on day 5, but on day 7. If it's issued on day 7, it is not a valid payment notice, even if the contractor wasn't, the contract didn't provide the claim. The contractor could make an application for payment before the due date, and he hadn't made one after the first date upon which he could issue, he could issue a payment notice, the 110A notice. So, in other words, depending on what the contract says, if it's the scheme, the date, if the interim certificate has to be issued on no later than day 5, if it's issued after that, the fact that it's been issued is irrelevant because it's not a valid it's not a valid payment certificate. So it's still dependent on the contractor. If he made his application before, that created the notified sum. As soon as the payment notice or payment certificate hadn't been issued, that created the notified sum. And you just go forward then, and the employer can issue a pay less notice. The fact that a certificate is issued late, too bad. It doesn't create the notified sum. If the payer issues a pay less notice after the date when it could or should have been should have been made, then notifying that it was going to pay less than the original notified sum, if that's issued late, then that again is an invalid notice. So it then created this concept that with each payment, interim valuation payment, each payment cycle, you could actually have what's called a technical or smash and grab adjudication, where the paperwork may have all been issued, but on the wrong date, or it didn't include the information setting out the sum that was going to be paid, or the sum that was being applied for, and how it was valued. If it didn't include both of those, it wasn't a valid notice. Even though it had been issued, it wasn't valid. So you ended up with these technical adjudications, which was simply on, let's say all the paperwork was issued, the payment certificate and the pay less notice, but it was all done on the wrong date or didn't include the right information. Then provided the payee, the contractor, had made his application and followed his process, if the payment certificate or the pay less certificate were, let's say, both invalid, then the contractor's application created the notified sum, which is the payer's obligation to pay. And therefore, just on the technicality of getting the dates or the information wrong in the notices, the notified sum may have been created by the contractor's application, and that's the one that had to be paid. So if the employer didn't pay the correct amount, then you could go to adjudication on a smash and grab basis and win the amount that you'd applied for. And that's what the ISG and CVIC case was about. So this case established that each interim payment cycle could be the subject of a dispute. Because the whole reason behind the creation of the Construction Act was to get interim payments to stop people not paying contractors and the contractor having no redress. It meant that the contractor did have some redress. He could still go after interim payments. So this particular case also established the concept that each payment cycle was to be considered separately and there could only be one adjudication per cycle. That has now changed, and you can have more than one adjudication per payment cycle in certain circumstances, which I will come on to later. In Leeds City Council and Waco, it was held that an application for payment was invalid because it was made early. Now, if in your contract you say that the contractor can make an application for payment no later than, let's say, 5 days or 7 days before the due date, then if it's made a month earlier, that's still before that due date. And in fact, this was a decision of mine. Waco, the original case of the adjudication I decided was Waco went after Leeds City Council for non-payment. What had happened is before practical completion, basically Waco had been fairly relaxed about making interim applications, and Leeds City Council had been fairly relaxed about paying them and dealing with their own certificates. It's JCT contract. So they'd both taken a fairly relaxed attitude. They hadn't stuck to the contract terms at all. Now then, in those days, back before 2015, when the contracts were when the contract was entered into, the JCT contracts in those days, once you reached practical completion, you had an interim payment, and then you had the next interim payment was due 2 months later. So post practical completion, every 2 months, you had an interim payment cycle. Now, in this particular case, Waco made an application in the middle month. So it was too late for the first month, but the Leeds City Council argued it was too early for the next month. Waco obviously said, no, it's not, because the contract says no later than 5 days before. The fact that it was 30 days before, it's still within that no later than, with which I agreed. So I actually decided that Waco were due, had created the notified sum. Leeds had not, it was a valid application, and Leeds City Council should have paid it. When they went to court, which was the Waco and Leeds case, which is not recorded, not quoted, not cited as an authority, what the judge said was, this is not, they went for summary judgment, and this is not a simple case. I need to look into this in more detail. Therefore, Leeds City Council, you must pay Waco the amount that the adjudicator, which happened to be me, decided should be paid. And I'm not sure it was 298 or 398,000 pounds, but it was quite a large sum of money. And the judge said, what you've got to do, because the whole purpose of adjudication is to maintain cash flow, Leeds City Council, you have to pay the amount that the adjudicator decided, and then if you want to get it back, you'll have to start the case, which is why the case is Leeds City Council and Waco. So Leeds was trying to get its money back from Waco on the basis that Waco's application was too early and therefore did not create a notified sum. And in that particular case, the judge decided that the fact that they'd not stuck to the contractual regime before practical completion didn't bind them until afterwards. Although there was a course of dealing, that they just made applications as and when, and they made payments as and when. For some reason, the judge decided at practical completion, all the rules changed and you had to go back to the contract. And so what he said was not that I got it wrong. He just said this meant the adjudicated decision in favour of the contractor could not stand, and he made Waco repay Leeds. Caledonian Modular and Mars City, the court followed the Leeds case and refused to enforce an adjudicated decision, finding the claimant's interim application for payment was made early and was therefore invalid. So basically, there's another case. I've given you all the references, so you can look these up if you wish to. But so that just reinforced and agreed with the Leeds case. In Henia and Beck Interiors, the court found that there was no valid contractor's payment notice. There was a valid pay less notice, and the employer could deduct liquidated damages even though the contract administrator had not decided the contractor's extension of time claim. So basically what happened was the contractor applied for an extension of time. The contract administrator hadn't decided yet whether any extension of time was due. So it was open then. There was no decision had been made. And what the employer said was, well, the contractor's now X weeks late, has liquidated in the damages in the contract. So I'm going to, it's the example I gave much earlier on. The employer decided to deduct liquidated damages, and therefore he should pay less notice in the amount of the liquidated damages. And the judge said, valid pay less notice, or the pay less notice was valid, and the employer could deduct liquidated damages even though the contract administrator had not yet decided the contract's extension of time claim. So in other words, that will prevent you making a claim if liquidated damages has been deducted by the employer before the contract administrator, or and depending on the form of contract, the project manager has actually made a decision on whether an extension of time is to be granted. Right, Grove and Balfour Beatty. It was held the contractor had no contractual right to make an interim application while the works were ongoing, but after an agreed payment schedule had expired. In that contract, what they did was, instead of saying that the due date was going to be the last Friday of the month or the 25th day of the month, what they did was they set out a schedule of payment due dates. Now, that ran on, they knew how long the contract was going to last, so they ran payment dates through. There was a long delay, and both parties executed the contract. There was a long delay to the start on site, not due to the contractor, which meant that once they finally, Balfour Beatty, got started, they made their applications in accordance with the schedule in the contract, but the schedule in the contract just stopped, and they still had to carry on with the building works. So they made an application, and Grove Developments turned around and said, sorry, your payment schedule ran out. We didn't say continuing every month thereafter or anything like that. We just gave a list of payment dates. So that's an end to it. You're not due any more interim payments. We're not going to pay. So they went to court for a decision on this. And what the judge said was the contractor had no contractual right to make an interim application while the works were ongoing, but after an agreed payment schedule had expired. This left Balfour Beatty having to fund £25 million worth of construction works, and they weren't going to get paid any interim payments. They had to carry on and finish the works. They weren't going to get any interim payments until basically the final certificate. That obviously Balfour Beatty didn't like that decision, so they went to the Court of Appeal, which is why it's EW, England and Wales High Court, and the reference is EWCA, England and Wales Court of Appeal. They took it to appeal, and the Court of Appeal agreed that the contractor had no contractual right to make or be paid for an interim application made while the works were ongoing and after an agreed payment schedule had expired. So now what you've got to be careful, and if you're looking at making a claim, and it's if there is a payment schedule, a list of dates, at the end of it, does it say and continuing at the same date each month thereafter or something like that? So in fact, there's no end date to the schedule. If there is an end date and you've passed it, you've had it for an interim payment. In Joabi Properties Interiors Group, the court held that a building contractor's valuation did not constitute a valid interim application in accordance with the building contract. Right, basically what the contractor did was he just sent a valuation, and I think it was post-practical completion, just sent a valuation. But they didn't say they were asking for an interim payment. They just said, this is, we're working through the final account. This is how far we've got. We're now at this amount of money. And then later on, they said, well, obviously you knew that when we sent you the valuation, it had gone up since the last payment and the last valuation when we were paid. So obviously it was obvious that we needed to be paid a bigger amount. And basically the court said, no, just sending an interim application, just sending a valuation of how far you've got through the final account or the value of the works to date is not good enough. You actually have to formally make an application and make it clear on the face of the document that you are asking for payment. Adam Architecture and Hallsbury Homes, the Court of Appeal confirmed that a party must give a pay less notice if it wishes to pay less than the sum claimed. I mean, that was basically simple. Paid less, and therefore they went to court and said, no, you didn't pay the right amount, you paid less. And the argument was over, you haven't made sent a pay less notice, so you've got to pay the already created notified sum, and the court agreed. So if you haven't paid a pay less notice, or you've made sent a pay less notice, but it's not valid because for one of three reasons. One, it's too late, so it's not valid because it's not within time. Second, it doesn't set out the amount you're actually going to pay. It doesn't clearly state the amount you're going to pay. Or thirdly, it doesn't say how that sum has been calculated. Gradually in S&T, it was held the employer's pay less notice was valid, even though it referred to another document to show the base on which the sums were calculated. Basically, what they did is, because at the time of sending the pay less notice to be valid must set out the amount you're going to pay and the way in which it's been calculated. What they did in this particular case, they said, this is the amount we're going to pay, and we sent you the spreadsheet last week, the Excel spreadsheet last week, which shows how it's calculated. Now, up to this point, I'd always advise clients that whenever you're sending a pay less notice, at the same time, even if you sent it before, send the Excel workbook or hard copy, whatever it is, but send the same information again. This decision came out, and so, in fact, following that, I would still advise clients to do so because it saves any argument. But in fact, they don't need to. If they've already sent the spreadsheet through, or the method to show how it's calculated, then that can be the pay less notice will be valid if they refer back to that. This case also casts some doubt on the ISG and CVIC regarding one adjudication per payment cycle. Now then, if you think about it, if you've got the paperwork wrong, you can have, as I described before, a smash and grab valuation and just say, you've got paperwork wrong, we've applied for this amount of money, your pay less notice isn't valid, that created the notified sum, our application created the notified sum, therefore that's the amount you should have paid. You could also have a dispute whereby for the same payment cycle, the paperwork's all in order, you just don't agree with their valuation. The contractor doesn't agree with the valuation. So the employer sends a pay less notice, or the architect certifies. The contractor sends in an application for, let's say, £100,000 interim payment. The architect or the contract administrator certifies a payment of £80,000, which then creates the notified sum. The employer does or doesn't send, it doesn't matter. He's got to pay the £80,000. Let's say he sends in a valid pay less notice saying he's only going to pay £60,000 because he's deducting liquidated damages, and he only pays the 60,000. All the paperwork might be right, and the employer may pay the correct amount, the £60,000, but you just don't agree. Therefore, you can have a valuation over the interim payment, which again is part of the process and part of the reason for having the Construction Act in the first place. So you can then have two, whereas before the original case, the ISG and CVIC, the judge said you can only have one adjudication per payment cycle. This case said, no, you can actually have two. You can have an argument over the paperwork, and you can have an argument over the proper value. So let's say that the contractor makes an application for payment for £200,000, and the architect certifies a payment of £100,000. The employer then goes through and pays the £100,000. All the paperwork's fine. What you can do, let's say the paperwork's not fine. The pay less notice is incorrect, which reduces the payment from £100,000 to £80,000. The employer pays the £80,000. What the contractor can do is he can have a smash and grab, a technical argument over the paperwork. He's applied for 200. The architect certified 100. That created the notified sum. There was an invalid pay less notice, but he only paid the £60,000 because that's what it is, his pay less notice. But the contractor can only go after, on that basis, the contractor can only go after the payment of £100,000 rather than the 60. If he disputes the whole, that's one adjudication. If he disputes the whole valuation, he may have another adjudication over the true value of the works. He should have been paid £200,000. And therefore, on each payment cycle, you can now have two separate adjudications, one or two separate disputes, one over the paperwork and the payment of the notified sum, and the other one over the amount the notified sum should have been. Now, the judgment in Grove Developments was upheld when the Court of Appeal dismissed S&T's appeal. So it is now confirmed that there can be more than one adjudication per payment cycle, a smash and grab and a dispute over the proper value. However, what the courts have also said is starting an adjudication to determine the proper value is dependent upon the first pay and the result of the previous smash and grab. So let's say in our example, the employer pays the £60,000. He should have paid the £80,000, sorry, the £100,000. In which case, you can have a smash and grab to get the extra 40,000 between the 60 and the 100,000. That 40,000 extra payment. But if the employer wanted to start the true value, then the employer would have to make payment of the result of the smash and grab before he could have the true value. So it maintains what they wanted to do was, where an employer's messed up, there's been an error anyway, and the contractor has applied for a lot more money than the architect's valued, and because the certificate is incorrect, it's not a valid certificate. Let's say we'll go back to the 200,000 which the contractor applies for. Architect certificate is the 100,000, but it's on the wrong date. It's too late, so it's not valid. So now the £200,000 is valid. The employer doesn't give a pay less notice, or gives one that's again too late, but then pays on the amount of the pay less notice. Then the contractor is due to be paid the £200,000 on the smash and grab basis, but the architect's only certified £100,000. So in that case, the employer would want to run a true value. And what they've said is simply starting a true value once you've got the result of the smash and grabs. Starting a true value doesn't delay the employer having to make payment resulting from the first smash and grab adjudication. So in other words, you have the smash and grab, lose, employer must pay whatever's decided, and then start the case to have a true value and then get the money back. Now, in Davenport and Greer, the court followed the Court of Appeal's judgment in S&T and Grove, which upheld Grove Developments thing. In doing so, the court reconfirmed the principle that an employer is entitled to refer to adjudication dispute about the value of the contractor's final account, but only after it's paid the first adjudicator's decision. Interim payment, this happened to be a final account. But in this particular case, the two adjudications overlapped. So the employer started the adjudication before the smash and grab adjudication had been decided. Now, when I say we, I mean adjudicators generally, thought that what would happen was the adjudicator in the second adjudication would be told he didn't have jurisdiction and therefore it wasn't valid. But the court didn't declare the second adjudicator did not have jurisdiction when the second adjudication was, it was commenced before payment, but after they'd got the smash and grab. So they tried to delay the payment by starting the smash. When they lost the smash and grab, they started the true value in order to delay payment, and the court said, no, you can't. You must pay the second, the amount decided by the first adjudicator before you can start. In this case, they started it before, they'd made payment, but the court didn't say the second adjudicator didn't have jurisdiction. In other words, although they'd started it and the two adjudications, one was finished, but the second one was started before payment had been made, they let the second one stand as well. Global Estates and Sudlows, the court held an adjudicator took a restrictive view of his jurisdiction when he excluded substantial parts of the defence, so as in breach of the rules of natural justice, rendering his decision unenforceable. In other words, if you're making a claim and there's lots of defences put in, the adjudicator has to consider them all. In Spencer and Tech Projects, the court rejected the responding parties' 3 jurisdictional challenge and enforced the adjudicator's decision. And in this particular case, the interesting thing was they'd sent, the scheme says, and the contracts say, send the notice of adjudication and then apply for the nomination of an adjudicator. And what they did in this particular case, they did it at the same time in the same email. They sent it to the contractor and applied the notice of adjudication. So the contractor sent the notice of adjudication and at the same time applied to the nominating body. Now, I've always told my clients to leave it an hour or two. So there's a distinct separation. You send the notice of adjudication, and then subsequently, you then apply for the nomination of an adjudicator. In this particular case, they did it at the same time, and the court didn't reject that, which again surprised me and a lot of other people. Downs development, the court declared that an adjudicator's decision was not enforceable due to a breach of the rules of natural justice and refused to sever the decision. In that particular case, it's an example whereby if an adjudicator is asked, there are several redresses sought, and one of them is out with his jurisdiction or he's due to a breach of the rules of natural justice, one part of it is not enforceable, then the courts have said that they'll pick the bits that are still valid and enforce just those. And the bits that aren't within the adjudicator's jurisdiction, they'll just ignore. In this particular case, the court declared the employer's payment notice valuing the interim application at £1 was not valid. And what they've done is the employer sent a payment notice valuing the works, the interim payment at £1, and then said, we'll give you our accurate figures later. So he'd sent a valuation in time showing just £1, but stating that he would send his accurate figures subsequently. In other words, after the payment notice period had passed. And what the court said about that was, no, you can't do that, because the challenge was, if you send an interim valuation saying we're just going to pay you £1, but we'll tell you how much we're actually going to pay you a bit later. If you remember on the early slides, it has to a valid payment notice has to show the amount that the person sending it values the works at, how much is due to be paid. Well, if you're sending an interim application or dealing with it and just saying we're going to we value the works at interim application at £1, but we'll tell you the proper figure later. When they sent the £1, it clearly wasn't a valid notice because it didn't set out the amount that they thought was actually due to be paid. CC Construction and Mincione, the court granted part of a declaratory relief the defendant sought and held that the adjudicated decision was only partly enforceable due to a material breach of the rules of natural justice. He failed to deal with the defendant's liquidated damages defence. I've only got a few more slides and then that's it, because I appreciate it's now 1 o'clock or almost 1 o'clock. TCC has issued a reminder that Section 111 of the Construction Act creates an immediate obligation to pay the notified sum, and any right to adjudicate to obtain a true value of the sum due is subjugated to the rights to payment. In other words, pay now, argue later. That's what they keep saying in the courts. Pay now, argue later. AM Construction and the Darrell Amam case. There's ample authority that the sum due under Section 111 of the Construction Act must be paid before starting a true value adjudication. However, this judgment clarifies that this principle applies even if the sum claimed has not been confirmed by a previous adjudicator's decision. It's enough for it to have fallen due under the contract. So practitioners also note the judge's conclusion that the contractor's service of an earlier invalid default payment notice did not prevent it from later serving a valid one. In other words, they sent an invalid one and then thought, oh, that's wrong, we haven't done that right. So they sent a second one, but the second one was in time and it was valid. In other words, you can correct an error in a notice, and I assume it can go in both ways, not only an application, but also in a notice as well. The TCC has confirmed that an adjudicator can have jurisdiction to determine the sum due to a party on either a technical or true value basis within the same adjudication. Now, I've had this whereby the contractor said, number one, we think they've got their paperwork wrong. We think that their pay less notice was invalid, and therefore we should have been paid. The notified sum was this amount of money, and that's what we should have been paid. If that's wrong, then as a backup, if we don't win on that one, we'd like you to consider the true value, because we still think that our application and we should have been paid more than their interim certificate showed. So in fact, rather than having one adjudication and then a separate one, this has now opened a bit of a can of worms up, actually. But it means then, in the one that I had, I found that the paperwork was incorrect, and therefore I didn't have to look at the alternative case. But in this particular case, they said that it was a valid pay less notice. However, so the claimant didn't win. The contractor didn't win on the smash and grab adjudication or redress. So in fact, the adjudicator then carried on and did the second true value, and the courts have said yes, that's fine. That's it. Those are my notes. I will now stop sharing.
All right, thank you very much. And it looks like everybody's still here. We've had a small but mighty crowd today. We do have one hand raised and no questions in the Q&A. So usually I save hands up for the end, but I'll go ahead and ask Mar. My apologies if I mispronounce your name, Mar Dowd. I'm going to allow you to talk if you would like to ask your question. And if anyone else has a question, please drop it in the Q&A box. It's the center or bottom of your screen with the two chat bubbles. Mar, would you like to speak?
He'll have to unmute himself. He's still muted.
I have allowed him to unmute. He just hasn't done so yet. So Mar, if you are trying to speak, please do unmute yourself. I have given you permission.
Oh,
and as I say, any other questions, please put them in the Q&A box.
I've confused them all.
Or else you've explained everything so clearly, they've got no questions. Okay, well, I will just let everyone know that we do not have webinars in July and August due to the summer holidays, or I guess winter holidays, depending on where you are. But we will be back in September with the conference. And again, please have a look at the website, instituteccp.com. There is a button at the top for the conference, and you can find out all about all of the sessions and the presenters. And don't forget to use webinar 275 for a discount, in addition to the early bird discount that is currently available. And okay, so Mar has not unmuted himself. No one has put any questions in the Q&A box. And since we are 5 past the hour, I guess I'll just give everyone a quick speak now or forever hold your peace. But Keith, I would like to thank you so much. That was quite an informative session. And I think everyone can appreciate getting walked through some of these cases. We don't often touch on specific case law, so it is good when we have someone who's willing to go through them with the members and our broader audience. So yeah, thank you very much. And the replay will be up in a few days. Just give me a few days to get that edited up. And I will have the slides along with Keith's contact details. If you realize after we've ended the session that you do have a question for him, he has very kindly offered to answer emailed questions. But, please keep in mind he is a consultant and you don't abuse his kindness. All right, well, I guess, I guess that's going to be it. Nobody has asked any questions. I think this is a first. You must be the first presenter to answer everyone's questions before they get asked. But thank you all very much. Thank you everyone for attending. Thank you, Keith and Paulina. And we'll see you after the holidays. Bye, everyone.
Thanks very much. Bye-bye then. Bye-bye, Jen.
Bye.